Well, good morning, everyone. Welcome to Judiciary Non-Civil. We'll go ahead and get started this morning. So we have 3 bills on the agenda, and what we've done is we've placed a sign-up sheet just outside the room. So if there are any witnesses who want to sign up, they can do so. And what we're asking is that, following our House protocols, all members of the committee, of course, will be in the room, but anyone else will sit outside the room. And when you were speaking into a microphone, the speaker said you don't have to have your mask on. So bill presenters and any witnesses can take their mask off. But we'll go ahead and call first SB 344, and Chairman Mullis is here. Chairman, go ahead and present your bill.
All right, thank you, Chairman. I really appreciate that, being in front of this outstanding and distinguished legendary committee, in fact. And you know, this is the very bill. Was that an amen? This is the very bill.
Turn up your volume as you said. Yeah.
This is the very bill we've been looking for. In this time and age where we're trying to find ways to save money, especially after the pandemic, and this is how we can do this. In fact, we're using this already, but this bill kind of codifies it, makes it completely in the books. But this is where if an inmate has a proceeding that is needed for that inmate's, I guess, sentence, or give me the word I'm looking for.
When judge considering
that's
the
right.
sentence,
That's
maybe,
right. Well, let's say they're in Ware County and their crime happened in Catoosa County, where I represent. Well, now with this, they can video conference and do all their proceedings online or via streaming. And it potentially will save lives with the loss of the corrections officers that happened in Putnam County a few years ago. It will save time. It will save money. And yet, the discretion is completely with the judge. If the judge wants the inmate to be right in front and center, that can happen automatically. But I can give you details, but that's the balance of this. And I have a couple of gentlemen here. Judge Kell and Stan Cooper that was with the Department of Corrections. They can give you some details of this bill.
Very good. Thank you very much. We'll go ahead and call on Judge Kell now. Chairman Mullis, if you'd like, you can just stay where you are. Okay. You're fine.
Yes,
and
sir.
Judge Kell, what is your number?
16.
All right, Judge Kell. Thank you.
Thank you so much, Mr. Chairman. I don't know that there we go. Thank you so much, Mr. Chairman. I'm very proud to be here to speak on behalf of this bill today. I was I think we were the second jurisdiction to be in the pilot program for this program, and therefore I have already used this methodology several times. We adopted a rule in the Superior Court that allowed us to test out this as a pilot program, and I'm just going to speak about a couple of things, and then I'll be happy to answer any questions about how the system works. But the one thing I wanted to make sure everyone understood was, as Senator Mullis said, when there was a proceeding in my court in Cobb County, let's say the inmate was at Reedsville prison, that I had to issue an order that inmate be transferred from Reedsville prison to Cobb County. The mechanism for how that happens is the inmate has to be placed in a transport vehicle at Reedsville. He has to be transported from Reedsville prison, in my case, to Jackson prison in Jackson, Georgia. The Department of Corrections has to have corrections officers who take him from Reedsville, put him in maximum security prison, take him all the way up to Jackson, another maximum security prison. Then Cobb County has to send 2 deputies in a transport vehicle just down to Jackson prison to collect that inmate and bring him all the way to Cobb County, where we have to house him for however long we need him or her, and then return them back to Jackson. They then get on another transport vehicle and are taken back to their original prison. So you can understand the cost savings that can be achieved by this program, the time, the effort, and also the safety factors for both the officers and the inmates themselves. Transportation is a dangerous thing. When you're on the highways and you're trying to achieve security, it can be a dangerous thing. I can tell you from our experience, because we've been keeping track of this, just the county savings, not the state savings, which Mr. Cooper can tell you a little bit more about, the county savings averages $2,000 per hearing. That's deputy time, it's transportation costs, the gasoline, the transport costs, the housing for the inmates. We save $2,000 per hearing. I just did a hearing this past week on Tuesday for an inmate who had a motion for new trial. He was housed in a South Georgia prison. We got him on the video. He had actually needed an interpreter. We had the interpreter who was set up on a phone line who could speak right into his ear. We handled the hearing very efficiently in about an hour and a half. Good morning. In about an hour and a half at a huge cost savings. And believe it or not, even the inmates like this system, because if they're in a trade program or they're in an educational program, they don't get interrupted, they don't lose their space, they don't lose their spot during the time that we have to transport them up and keep that. So I think it's a great program. It has worked very well. And the other thing that I will say is Department of Corrections, number one, has set up a great system for us that's very efficient. Number two, we have also tried to put into the bill all of the safeguards that we could to safeguard both the constitutional rights of the defendants and the inmates, but while also achieving a system that works for everyone. So thank you very much again for letting me be here this morning. If you have any questions, I'll be happy to answer those, and I know Mr. Cooper has some comments he'd like to make.
Judge, any input from members of the bar as far as representation, communication with clients, and responsibilities along those lines?
Yeah, I'll commend Department of Corrections for listening to defense bar to try to set up a mechanism. For example, the DOC has set up a phone communication system so that defense attorneys in advance of these hearings can have direct access to their own clients via a phone system so that they can get ready for the hearing and talk to them in advance without having to do what they used to have to do, which is get in a car wherever they were, say in Cobb County, drive all the way to Reedsville Prison, meet with their client sometimes for 15 minutes and drive 4 hours back to Cobb County. DOC has been very generous in setting up and efficient in setting up a system where they can just make an appointment. The inmate will be placed in a telephone booth room, and the attorney can talk directly to their client in advance of the hearing. And there's also a mechanism for doing that during the hearing if the inmate needs to talk to their attorney as well. Yes, it is. Yes, sir.
It's confidential.
Yes,
All right.
sir.
Vice Chairman Reeves. What's your number?
4.
Okay.
Thank you, Mr. Chairman. Judge Kell, thanks for being here.
Glad to be here.
I'm looking at mostly line 45, and I understand that the way this is set up is that a party can object and request an actual in-person proceeding. And then it says on line 45, if the objection is made, the judge may require their personal appearance to court to testify. How are you seeing that concept play out, or how do you foresee it playing out? And if we look at lines 21 through 41, it covers, it looks like just about everything except for perhaps a trial.
Yes, sir, that's right.
And some of these are obviously more sensitive proceedings than
Yes, sir.
others. And one of the things that I've learned in the last 3 months in practicing law is that there's a value sometimes to all being in the same room and seeing face to face,
Sure.
and the body language and everything that comes with that, and you lose that through the electronic proceedings. And just how do you, obviously the judge is going to have a lot of discretion here, and I think that that's important because I can also see how this could be used as gamesmanship to try to cause delay and things like that.
Right.
But what is how do you anticipate from talking to your body and the judges, is there any kind of uniformity that we can expect on the kind of things where a judge will allow will not override, let me think of how I'm trying to say this, where a judge will allow a defendant an in-person proceeding as opposed to a electronic one with the discretion that they have in line 45?
Sure. Well, let me first tell you what my experience has been so far. I've probably conducted at least 20 of these hearings, some of them things as large as a motion for new trial, which, as you know, takes sometimes a couple of hours, maybe sometimes half a day. And then some have just been very short routine hearings that we've had. my experience thus far has been that not a single attorney or defendant has asked me not to do the proceeding as a video proceeding, because the efficiencies that are achieved by allowing these hearings to proceed is beneficial to everyone. As I said a minute ago, even the inmates seem to like this system because they don't lose their place at their prison, they don't lose their bed space, those sorts of things. In answer to your question, though, as with all things where judges have discretion, it's going to be decided on a case-by-case basis where there are good reasons for those things. I think in this era where we are starting to have many more video hearings than we've ever had before,
Sure.
I think as a judge, I am learning to adapt my style to recognizing things on the video screen that I never really had to pay attention to as much before in the courtroom setting. And so I think judges will be attuned to those. But I also think, at least in my case, if somebody wants to be in a courtroom and it is a proceeding that is, not a routine proceeding, not something that is just pro forma, I may very well want them to be in that setting, and it gives me the discretion to say I'd rather do this in person than by video, and I can see that. For example, in a motion for new trial setting where we're going to have multiple witnesses, and I'm going to need to look at demeanor and credibility issues and things like that. So I think it'll depend on what issues are being raised, what the thing is, and again, that's kind of what we do as judges when we have to exercise that discretion. But yeah, I think that's a safeguard that is within that statute.
Okay, thank you.
Yeah, thank you.
Representative Dickerson.
Thank you, Mr. Chairman. I just wanted to know about the smaller counties, our smaller counties outside of the metro areas. Would this cause any unfunded mandates to them, or would this be beneficial to them?
Mr. Cooper.
No, ma'am. Thank you, Chairman. No, ma'am, not at all. They actually, every county, it's not a mandatory thing.
Okay.
It's an option for every county. Mm-hmm. And if I may, just to give you some statistics on what's happening right now in this state. When this bill was passed in the Senate in March, we as Judge Kell and of course Chairman Mullis has mentioned, we ran a pilot for about 6 months. July 1st of last year, we actually went statewide and offered this up to all 49 judicial circuits. Since that time, when the bill was passed in the Senate, we had 10 circuits that had opted in and was actually utilizing it. Since then, we're now up to 30, and as of next Friday, we'll be up to 31 circuits in the entire state of the 49 that is using some type of video hearings with us, and not just with the Department of Corrections. They've actually taken it a step further. Now, some places have actually purchased and placed in their county jails the same system, so that they can stop transporting inmates from the county jail to a courthouse. And a lot of the counties, the administrators have purchased the equipment to do it. Many already had existing equipment, so there's no unfunded mandates with this.
And if I could say one other thing about that as well. In our county, what we've seen is that the cost savings that we're achieving, by the time I've done 5 or 6 of these hearings, we can justify the cost of the purchase of a system. It's about $11,000 or $12,000 for the video equipment that's needed on our end. Department of Corrections funds the things on its end. It's about $11,000 with a cost savings of about $2,000 per hearing. By the time I've done 5 or 6 of the hearings, we can justify that cost. And our county was very receptive to the idea that we could save that much money simply by putting in a system that would cost $11,000 or $12,000. So I think for the smaller counties, it's going to be a big benefit in cost savings as well.
Thank you, Chairman.
All right, Representative Bodie, you number 9.
Thank you so much. Thank you so much. I was talking with Vice Chair, and we have just some of the same concerns, but I think Judge Kell and I had the honor of practicing before for the last 10 years now.
Yes, sir.
And I've had this issue actually before Judge Kell. Line 27, the intro of pleas in criminal cases. First of all, Judge and Chairman Mullis, I love this concept because I know this has been able to speed up even when you're going to see your client at the jail and you have video conference.
Yes, sir.
Used to take an hour, hour and a half, and maybe now it's less than 30 minutes in some cases. We're getting in and out. But the entry of a plea, you know, Judge, sometimes pleas break down, and, you know, I know you tell me, hey, you know, go talk to your client and, you know, see what we can try to do in the plea colloquy. And, you know, and that's the only reservation that I have, because I just want to make sure we have safeguards when that does happen, that what could be the proper protocol to deal with that, Judge?
We have the ability with the system that Department of Corrections has set up to actually allow the attorney and the inmate to go offline on the system. They have a direct phone link that is, in fact, I just did this the other day on the hearing that I had, because we had an interpreter who was working in that hearing. We actually put the interpreter on the phone link so that the inmate could hear, you know, better than just over the video system, and we could have simultaneous translation. So we basically use the same phone link that the attorneys and the clients can have. They can talk directly. We take them off the video system, and they've got an ability to be outside everybody else's presence and talk one-on-one, and it works really well. I've used it already in hearings that I've been doing, so that they can immediately have that private conversation, and then we can get back
on the record,
to taking the plea and going back on the record.
Thank you so much.
Sure.
Thank you for that clarification.
Yeah, absolutely.
Representative Setzler.
Thank you, Mr. Chairman. Judge Kell.
Good morning.
Welcome back.
Great
How are you?
to see
Good to see you.
Always a pleasure.
What in the sweep of Superior Court cannot be done this way? Which kinds of proceedings does this bill not allow to be done remotely?
Obviously, trial proceedings. We're not going to try to do, although I got to tell you, in the COVID era, we're trying to figure out ways that we can get some things done because of the backlog of cases that we're obviously going to have. But this bill does not include a provision for us to do trial proceedings. It also excludes, oh goodness, I know we had a couple of other exclusions, and off the top of my head I can't remember what they were, but they're those kinds of in-person proceedings with potentially multiple witnesses and those sorts of things. And again, on any proceeding that the defendant or anyone else wants to have in person, they can ask for any of those proceedings to be taken up in person in the judge's
That was my last question. I know there was some discussion earlier about it, but I just so by right, if somebody's liberty is in jeopardy or their property through a civil proceeding, by right, you may be present in a proceeding. I'm seeing some heads shake the other way, and I asked the question because I just, to me, the idea, I'm just philosophically stepping back a little bit, the idea that my life or my liberty or property is in jeopardy, and I've been, well, no, you had your day in court. You know, you got to do video court. You know, the idea to be able to stand in front of a judge and even people who aren't, you know, the great speakers that some people in your profession would be,
Sure.
In the law profession, they still may want their presence and the significance of their being present in front of a judge and others to be manifest in the hearings. And I just, I just want to understand if there's anything that would prevent somebody from having by right the ability to be there. That gives me concern, and I need to be comfortable with that.
As you'll see, if you go through the list of the proceedings that are listed here that are contemplated where defendants would be, where video hearings would be used, the majority of these are post-trial type proceedings. Now, there are a few exceptions to that. For example, where we're doing an arraignment, which is an initial proceeding. Normally that's about a 5-minute proceeding in my courtroom, and we transport hundreds of inmates from the county jail and sometimes many from the prison system for arraignment. An arraignment is simply where I read the charges or the DA reads the charges to the defendant, and they enter their initial not guilty plea to those.
Are there any proceedings in here that are contemplated that are in front of a jury and not just a judge?
No, sir.
So this
Jury proceedings would not be held via video.
Because Mr. Chair, I just asked the question because if I were in a circumstance, even in something that were and again, you talk about civil settings, a custody case or something like that. I mean, if I were doing, 10 years, 4 to serve, and I'm sitting in Reidsville, and my wife, who I'm been estranged to, is making a motion to get sole custody of my kids, and he's a deadbeat, and now he's in prison. Let's just cut the cord. I need these kids. We're going to move on in life. And I'm sitting there looking at a judge, telling them why I'm getting out in 18 months, and I don't want her to have complete control of my children. I want to be physically present there. I don't want to be in, you're clear down in Reidsville. Cobb County's it's a long drive for you now, so you get to be on the video. I have a real issue with that.
Sure.
So I'm just, in the spirit of conversation, that's my starting point. But I think it's with us having federal court cases by Zoom, I know it's a new day, but I think there's some things we just, by right, I think people should have some opportunities to be present. So.
Yes, sir,
Mr. Chairman,
Cooper.
if I may address
Yes.
some of that with him through our experiences and doing this now for a year. One, let me say this. We've actually had all those examples you're giving coming up. And what we've seen is this: many judges will always side on the caution side and bring that inmate in, which we fully support that. And so that's been brought up, and I've had judges tell me, I just don't feel comfortable doing it this way, so we're bringing them in to do that.
My concern, though, is not to pick on an entire generation of people,
Right.
because a lot of them vote for us. But a millennial judge in 25 years or some amount of time that says, you know what, we just need to be more efficient about this. They've kind of grown up in this culture of video hearings, might be a little bit less sensitive than someone perhaps in our generation would.
Right.
So I'm just sensitive to that as well.
All right. Ms. Nesbitt just sent me a text. I think in lieu of testimony, she wanted the committee to know that ACCG fully supports this bill, and so just without having to call her in. So, Mr. Bodie, you have another comment?
Follow-up
Yeah.
question. And Judge, you may be able to help with this.
Will you pull your microphone up?
I'm so sorry.
That's all right.
Lines 44, 45, Judge. Is this, and I'm trying to read it, is this an opt-out? Because I wanted to know kind of what Chair Sessler was saying. Is it a possibility where if a client, a defendant, I'm sorry, because I'm thinking in terms of my practice now. If a defendant objects, can a defendant opt out and say, Your Honor, I understand my rights to have a video conference, but I feel more comfortable with coming in person. Can we maybe have a petition where the defendant can file that, and the attorney can file that on behalf of his client or her client?
Yeah, in any proceeding, the defendant has the ability to ask the court to allow him to do an in-person proceeding. There'll be notice if it's going to be, or if it's anticipated to be a video proceeding, but if they want to ask the court, request of the court that they be allowed to even if it's an arraignment, even if it's something that's going to be a 5-minute appearance in court, they can ask the court. It does give the court the discretion to make that determination as to whether or not that will happen. That's the way that the bill is worded at this point in time. And I'll tell you a really good reason for that is if you don't leave it within the discretion of the trial court, you run the risk that one side has the ability always to keep there from being these kinds of proceedings via video. And I think the only way to achieve a balance with respect to consideration of those proceedings that there's a real good reason for having in person instead of having video is to allow the trial judge the discretion to make a determination as to whether or not it's a proceeding that needs to be in person. As Representative Sessler said, I'm very sensitive to that, to exactly what you just said, which is if a man's or a woman is facing the potential of being in prison for any period of time, there may just be a reason they want to look me in the eye. It may not be their accusers, it may not be the DA. They may just want to look me as the judge in the eye and be able to plead their case, looking me face to face, and I understand that.
Thank you, Judge.
Did that answer your question, though?
Yeah,
I wanted to make sure. Thank you.
All right, couple more quick questions. Representative McLaurin.
Thank you, Mr. Chair, and thank you, Judge, for being here. Just to put a couple of your comments next to each other, I would like to ask you, it's hard to formulate this question exactly, but a couple minutes ago you said that defendants and their counsel are often choosing to exercise a video option, or they're eager to do it because
in every one of my cases,
because there's lots of practical reasons why. And yet, on the other hand, you've also commented that it's good to keep the discretion with the trial court because, defendants potentially could use this for gamesmanship or somehow, drag out proceedings or impose costs. I guess my question is, do you consider this, though, the right to be in person, as Representative Setzler says, in pre-conviction settings? Do you consider that to be sort of a fundamental right on the same level as other rights that criminal defendants are afforded without trial judge discretion, or do you feel that in-person setting or flavor is more of an optional feature of the system? I guess.
Sure.
I would ask the committee members right now if we could really stick to the language in the bill and hold on the question strikes me as more of a philosophical position, which maybe, respectfully, is outside of what we're really here considering today, which is the language. And I admit I've got 2 other bills on the calendar here today. So I would ask the gentleman if he's willing to maybe speak with Judge Kell offline, get his perspective on the answer to that question. Maybe we can really focus in on the language here. Certainly, if there's an issue as you see it as to the language, then we should drill into that.
Well, in 10 seconds, Mr. Chairman, what I'll say is that on line 45, the word may, whether it's may or shall, kind of makes all the difference here. I mean, unfortunately, I feel that the philosophical question is an upstream question that, if you answer it, determines whether the defendant gets sort of a structural right to be in court in person or not. And so if we're going to elide philosophical questions when we're experiencing fundamental changes in technology and talking about fundamental, constitutional rights of defendants, I think this is the exactly appropriate setting to be talking about.
So it strikes me then the question is, should discretion be given to the court to make that decision, or should the defendant have an absolute right to appear in court?
Correct,
Is that fair?
Mr. Chairman.
Right,
Exactly.
Judge?
Well, what I can address, or what I feel comfortable addressing, is the reason that the language is the way that it is. Certain proceedings have already been excluded because they didn't feel like the kinds of proceedings that ought to be conducted by video in any circumstance. That's the trial cases, the case where somebody is in front of a jury. Obviously, we don't want to do that by video, even in front of a judge where it's a trial setting. However, on the other hand, there are proceedings such as a guilty plea that's being entered by agreement. Everyone has already agreed. This is the sentence. This is the plea that's being entered. Other than a breakdown like Mr. Bodie talked about, which we've got a provision for so that we can deal with that, everyone essentially knows that unless the judge is saying, I'm not going to accept this plea, it is going to happen exactly as everyone has already agreed that it's going to happen. In that circumstance, the defendant already is asking the court to accept what he and the DA have worked out. And so in that circumstance, we believed it was a protection of everyone's civil rights to allow that proceeding to happen via video, no transportation of an inmate all the way across the state in order to do what everyone was asking the court to do. Same with an arraignment, which is a pretrial proceeding. We all know what's going to happen there. The charges are going to be read, and then the defendant is going to enter a not guilty plea in that. So we felt comfortable that under those circumstances, but even in that situation, the defendant could ask and say, hey, Judge, there's a real good reason I need to be there in person for my arraignment. I don't hear very well. I don't see very well. I have an issue that will prevent me from protecting my constitutional rights. So those are the reasons that I know that some of this language was placed into the statute the way it was.
Thank you.
Yes,
All
sir.
right, Representative Kendrick.
Thank you, Mr. Chair. I have a question from a judge, a traffic court judge that's in my jurisdiction, and he wants to know if line 27 includes violations of the traffic laws in the state, because he's a traffic court judge in DeKalb County.
Mr. Cooper.
Yes, ma'am. That's exactly the purpose for this bill. And just to clarify, the uniform rules, this bill basically follows the current 9.2 rule of the Supreme Court.
Superior Court.
So
Uniform
Superior Court rules. So And so it's authorized by that now. We seek to codify so we can expand that to include those types of courts, magistrates, state courts, and others, so that everybody is it's the same everywhere then.
And if I could add one thing to that, Mr. Chairman, one of the good reasons for that is, for example, I may have there may be a defendant who's already been convicted in another county who's serving a 10-year sentence in a prison across the state, who also has a misdemeanor charge pending in Cobb County, which might be preventing him, because it's pending, from going into a drug treatment program or an educational program. The ability for him to go ahead, or her to go ahead and enter that plea so that they can move on and get into those programs without having to come all the way back to Cobb, sit there for a couple of days, and then go all the way back is a huge advantage on both sides.
The access to justice issue is real. All right, we have two other. I'd ask our witnesses to stay where they are so that they can answer questions, but we do have two other witnesses we need to hear from. So let's hear first from Jill Travis of Gactel. Chairman Silcox, would you mind? Thank you so much. Chairman Silcox, if I could ask, would you also send Robert Smith in so we can just expedite? So, Ms. Travis, if you'd just like to have a seat at one of these chairs with a microphone, I'll turn your microphone on. Thank you, Chairman. Very grateful. Yes, anywhere you'd like to sit, Mr. Smith. All right, so we'll first call on Ms. Travis. Are you at number 12? 11.
I'm just trying to make sure my phones are off because I'm trying to listen outside to what's going on inside.
Will you test your microphone, Ms. Travis? Make sure. Very good. Thank you.
11.
Thank you.
Good morning, everybody. I will start. Appreciate being here. Thanks so much for this concept, because right now during COVID, this is super useful, and we agree with the spirit of the idea of having the ability to have remote testimony. The problem is some of the language in the bill. First of all, we think we should start with the concept of whenever, whatever it is, the parties agree by consent that we do video, we should do it. That language isn't in the bill. When we don't agree, that's when we have to deal with what happens next. Judge Kell is extremely reasonable. I believe that in Judge Kell's court, there wouldn't be an issue of the defendant objecting and not being able to have a hearing. But not every judge is Judge Kell. So the language at line 45, if objection is made, the judge may require the prisoner's personal appearance in court to testify. We think that should be shall. I hear what they're saying about gamesmanship, but the defendant does have a right to be present in court for some proceedings. The starting point of consent being missing from this also leaves out things in this list, for example, calendar calls, status hearings, objections to virtual hearings. Although this bill does look in some ways like Superior Court Rule 9, it doesn't mirror it exactly. Let me give you one specific example, and that is at line 34, acceptance of the plea of mental incompetence. It's it's the plea of insanity in the Superior Court Rule. Mental incompetence and competency to stand trial seems like something probably you're going to want to have judged in person. The thing is there is a COVID task force. Mr. Smith is serving on it. Gactel has a representative on it as well that is discussing all of these virtual hearings. And the starting point of that committee, again, is consent by the parties. And the other thing is if it's a not complicated plea, you can have a plea in a case that it's extremely, it's contested, and there's witnesses, and that's the kind of thing you might want to have in person. But you can have an agreed upon plea where you don't need to have the people come in from prison. And it's interesting, this code section that's being amended is 241360. It's the evidence code, and it deals with prisoners. And the conversation here is not only prisoners, but we're now also speaking about people in county jails for purposes of, for example, probable cause hearing. That's at line 24. And again, you can have a probable cause hearing where you can do it remotely. The case in Brunswick was done with some remote testimony. It's not that it's impossible to do, but that was agreement. That was agreement of the parties. The other thing is as Representative Bodie brought up, when the plea breaks down. So I want to talk a minute about just the nature of conversations. Some of you, most of you, I've spoken to many times over the phone and in person. And we have a relationship, but trust comes from having a relationship. So if you've got an attorney that doesn't have a relationship with a client, sometimes they're meeting them for the first time in court. And I'm not saying that Department of Corrections or a sheriff should be the messenger all the time, but in a time where we're looking at cost savings, we have a public defender's office that may have to travel to a distance to be able to see their client. Now, they may be able to establish that relationship by phone, but it's something to keep in mind. Cobb is an opt-out circuit, so it's a little bit different in that circumstance. Some of the things that I would recommend be changed is that it be by consent, that the matters be non-complex. At line 30, when we're talking about probation revocations and misdemeanor cases, again, that could be a very simple, uncontested issue. A motion for a new trial could be done very simply with legal arguments, and there would be no reason for the inmate to be present. Another change that I would suggest is on line 43, the notice of the hearing being conducted by video conference. In the Superior Court Rule 9.2, it's 30 days notice. We've only got 10 days notice here, and you notice it says within 10 days. So you could do it at 6 days, and then it's awfully hard to scramble about that. At line 45, changing the word may to shall. Another issue that might present itself in a contested hearing is how much documentation is involved between the parties. Also, with respect to lines 72 to 77, when we're talking about, we have to, of course, have open courts, and there might be a circumstance where a defendant's mother or father might want to be present for that. They would not be considered an interested party as defined by the lines 75 to 77. It's only a victim, and it really should be an alleged victim, because there's not a victim until there's a crime. There's not a crime until there's a conviction. With respect,
If I could just stop you there, Judge Kell, isn't the courtroom still open? The video feed just is there in the courtroom, but members of the public can sit in the courtroom like
Absolutely.
usual.
By law, we are not allowed to conduct these proceedings unless they're open to the public, and so the way we conduct them in my courtroom and the way most that I'm familiar with conduct them is everything is up on a video screen in an open courtroom that any member of the public could be present at.
The responsibility for an open courtroom isn't eroded by this bill whatsoever.
Okay.
All right.
In
Thank you, Ms. Trav.
In fact, I could be.
I withdraw that.
I could be in trouble for not doing that.
That's what I thought.
okay. And then, so the other thing I guess I'll point you to is with respect to the section 2, and it's sort of like kind of the overall global thing with regard to consent. In 35.3, 154.1, which you don't have before you, it's admission of reports from the state crime lab. And it says the defendant may object in writing, and if objection is made, the judge shall require the employee to be present to testify. I mean, there are certainly things in this list of section 2 that don't make any sense to me, like why a crime lab person might be necessary to be at a determination of indigence and appointment of counsel. So, I mean, I think the argument that's being made is that, well, what's the harm of having this same list? And I would just point out that why would you put things in that aren't necessary? Another at lines 116 to 118 about preserving the confidentiality of an attorney-client relationship has nothing to do with a crime witness testifying. And again, at line 135, if objection is made, the judge may require the employee to be present. Ask that to be shall, just as it is for the crime lib in 35.154.1.
All right, thank you, Ms. Travis. Mr. Smith.
Thank you very much. Just wanted to say that the prosecutors, are in support of this bill as it's drafted. I will point out in response to one of the comments that was made, when a prisoner is confined in any prison or correctional institute under the jurisdiction of the Board of Corrections, so that's somebody who's in prison doing a prison sentence, or in any county correctional institute, that again is someone who is post-sentence. This is not the county jail. That's a correctional institute. So we're talking about prisoners, not somebody who is in the sheriff's custody. But otherwise, we're in favor of this. It's a bill to. One of the problems we run into from time to time is having a crime lab witness be summoned to spend their entire day driving back and forth to testify for 5 minutes as to the contents or the quality of drugs.
Or to not be called to testify and have to return on a different date.
Yes, sir. So thank you. We asked for this. We are in support of this bill.
You need to ask a question. Can we?
Are you entertaining motions on this today?
Yes. Yeah, I'll hear a motion on it. All right, any questions from any of the witnesses?
I'm sorry, one follow-up. Again, with the chairman's exhortation, I don't want to get too far outside the four corners of this bill. I will say, parenthetically, I'm sensitive to rights we give to people. I'm both concerned about the rights of prisoners in our prison system being fully effectuated. I'm also concerned about rights that we give to prisoners we don't give to others. I mean, I've had people that would love to be able to go to participate not as a prisoner but as a free citizen that doesn't want to go to Brunswick to appear in court for something, and we're not giving them the right to do that too. So again, I know it's outside the four corners of this bill, but I asked the question, when my son's got to get in a car and drive hours away because of an ambiguous offense in some other state, a traffic offense, which oftentimes people just write the check even though they know they didn't, it was a traffic camera thing that was a mistake, just pay it to kind of make it go away. I'm sensitive to that too. I do think, I would just say parenthetically, I think we need to think about this for citizens that would want to do this. But I do wrestle with this issue of, because you're in prison and you're in the prison system, you get virtual justice as opposed to somebody being able to go face. That's just I wrestle with that, and I think there is a little overpressure against a person in prison to say, hey, I want to appear personally, because judges are people too. If they come in and they insist on the right, they show up in court. The judge is perhaps going to be a little bit ticked about that. I mean, there is sort of there is a little hesitancy in the human interplay of all this to, hey, let's just do this remotely. We can move this along. I'm just concerned that if you're in the prison system, it can be decided that you get virtual justice. I'm not willing to send my kid off to get a virtual college education, and I wrestle with it. I need to feel more comfortable. I'm all ears, but I need to feel comfortable with it. So
very good. Well, to the chairman of the Senate Rules Committee, this is what happens when you have a legal bill and a bunch of lawyers in the room to really go through it. We pride ourselves in judiciary with really going through every inch of a bill.
Yes, you can see.
You're not the first who've said that.
And in fact, when you give me a chance to close, I'd like
yes,
to have a
sir.
few words.
Yeah, this is the time for that.
Well, look, this is in our unusual time that we're in, and we're looking to save money, but we do not want to violate anybody's constitutional right to be heard. Now, I don't think anything should be a shall. I think that in most proceedings, I'd say the judge has pretty carte blanche ability to control the courtroom, and I think this is no any other way is the same as that. And this again will save money, and it will save. It'll be a safety thing, and yet no constitutional right is violated here. This is not the trial. This is not the jury trial. This is proceedings to get up to that point. And I dare say that there's not been a judge that has resisted any request to have the inmate or whoever come before the judge instead of by video camera. So I would recommend and appreciate this committee seeing this going forward too.
Thank you, Mr. Chairman. I'll entertain a motion at this time.
I'd like to make a motion to pass.
All right, there's a motion due pass from Vice Chairman Reeves, a second from Chairman Silcox. Are there any proposed amendments? Representative McLaurin.
Yes, Mr. Chairman, I might have a couple depending on how you want to structure them, but the first one would be line 45 to change the word may to shall.
Why don't you list out all of your amendments,
Okay.
and we'll just do it as one.
Okay. The next one would be.
You don't have any objection to that, do you? You do? You want to? That's fine. So, okay, first
Up,
one's
down.
45, may to shall. All right. Is there a second? All right, there's a motion, a second for the McLaurin First Amendment. All those, any discussion?
Mr. Chair.
Yeah.
Are these considered friendly amendments that the author would mind, or would the author be an
The Chairman Mullis has said that he's opposed to this amendment in his closing. All right, all those in favor signify by saying aye.
Aye.
Any opposed? No. All right, we'll do a hand vote. All those in favor signify by raising their hand. 1, 2, 3, 4, 5, 6. 6. All opposed? 1, 2, 3, 4, 5, 6. 6, 6. Chair votes no to the amendment. All right.
Okay.
Next.
The
Next amendment.
Next proposed amendment would be to add a subparagraph C right after line 50. And that subparagraph C would read, remote proceedings may not be conducted unless a defendant knowingly and voluntarily waives the right to appear in person.
All right. The second McLaurin amendment has been stated. Is there a second? Second. All right. There's a motion and a second. Any member need the amendment repeated? All right. Hearing none. All those in favor of the second McLaurin amendment signify by raising their hand. 2, 3, 4, 5, 6. All opposed? 1, 2, 3, 4, 5, 6. 6. Chair votes no, so that fails. Is there another amendment?
Seeing the will of the committee, I'll forego any further amendment.
All right, thank you, Representative. Any other amendments or further discussion? All right, seeing none, the Senate Bill 344 is passed in the Senate, is now before the committee. All those in favor signify by raising their hands. 2, 3, 4, 5, 6, 7. All opposed? 1, 2, 3, 4. 7 to 4. Bill passes. It's on to rules, Mr. Chairman. There is a Rules Committee form. I'll be happy to sign that for you.
Yeah, I know all about that. And let me tell you that the Senate will have a similar form, except ours is much longer now.
It's
Except for my friends.
not for Chairman. Yeah.
Mr. Chairman, thank you very much for the opportunity to appear before this committee. There are very many friends in this room, and I appreciate all of your input on all parts of this bill. I'll stick around for a few minutes, too. If anybody wants to speak to me, I'd be happy to talk to you about my thoughts about the bill. But thank you all very much.
Thank you, Judge Kell. Senator, who's carrying your bill?
You are.
Okay. I'd be happy to.
That's what I understood.
Yeah, okay.
And look, do sign that form. I'll come back.
Yes, sir. All right. Thank you. Thank you, Chairman. All right. Would you mind sending in Senator Strickland? Thank you. Thank you. Yeah. Middle right here.
Get over there.
All right. Morning, Senator Strickland. Do you have any witnesses with you
I do
today?
not.
Okay.
Not that I'm aware of.
We're just letting witnesses come in the room. Speaker said that when you're speaking in the microphone, you can remove your mask, so you're welcome to do that. And we'll go and call your bill, Senate Bill 435, for a hearing at this time. Senator Strickland.
All right, thank you, Mr. Chairman, members of the committee. Am I on, I guess?
Should
now?
be, yep.
I bring to you Senate Bill 435. This bill comes as part of the governor's package of the bills, but this is the First Lady's bill. And as we continue, of course, your leadership over the years in dealing with human trafficking in this House and the Senate's leadership on this issue, this is another bill that helps address human trafficking in our state. And in particular, we're trying to help more with the victims of this industry. And I can tell you, in some of the visits I've done, in particular, I've gone with the First Lady to some places where victims are living. And the biggest hurdle they have, outside of the emotional impact that human trafficking has on them, is trying to get employment. You have literally one of the places I was at, they said they've had people pull up to the front gate and have had girls run out of the house at night, run to that gate and go back to a John. And not only are they dealing with all the things that I can't even describe of the mental impact that this has on them, but part of it is how do you get out of it? And they end up relying so much on these folks for everything. And one of the things we wanted to focus on was employment and not letting that add to the reasons that someone may go back to this life. And so with Senate Bill 435, we're really doing two things. In Section 2, we're providing a way to have a former conviction vacated, which means not only does that get off your record, but even goes so far with it being vacated to have a fine repaid that you may have paid for that conviction. And here's the standard under Section 2. That's a very extreme thing in our law to have something vacated. And you have to show as a defendant that the conviction you had was the direct result of you being a victim. And if you go through the bill with Section 2, you'll see how that process plays out. The prosecutor has a big role in this because the first part is that a form is produced by the AG for this, and the victim will request to the prosecutor, will file a request to have this done. And you see starting on line 28 and 2B there, that it has to be 6 months after sentencing of a misdemeanor or 1 year after the completion of sentencing for a felony. And then you see, as you go down, about the fact you can get a copy of your criminal history free of charge to include with this, and you may, starting in line 36, include some documentation to justify showing that you were a victim. And on down towards the bottom, you see that if a prosecutor consents to the petition within 30 days, or fails to respond within 30 days, that it shall be granted. If they object, there's a process where a court will hold a hearing, and you see line 61, the evidence standard preponderance of the evidence, and a judge will decide whether or not the victim did commit that offense as a direct result of being a victim of human trafficking. And as you go further down, line 75, you see what happens if that's granted. And as I said, the crime is vacated, and only does the crime come off your record, but any fines or fees are repaid as well. So that's Section 2. In Section 3, the next part of this is a little bit different standard because this is record restriction. So not just vacating, but record restriction itself. And this is for any offense that's committed while you're a victim. And so one of the things I learned in this, and I'll be brief, but I want to give a little bit of background if I can, Mr. Chairman. Not only do you have crimes that a victim may be forced to commit as being a victim, but other things they may do, and a lot of these victims committed other crimes that weren't directly forced upon them, but they did it while they were a victim. And all the things that go through your mind as a victim, we find the propensity to commit other crimes while you are a victim. And so this is a different standard. It doesn't allow for vacating of sentence, but if you can show you committed a crime while a victim, same process as before in Section 2 that you go through, but you can have something removed from your record. And I can go into more details if you want, Mr. Chairman, on some of the weeds of this, but that's what we're trying to do, is just help do something else in our state to help the victims get away from human trafficking with this bill. With that, I'll be happy to answer any questions.
The battle against evil criminal empires perpetrating human trafficking, criminal enterprises, I think continues, and I have met with victims who have committed crimes such as shoplifting, such as other offenses when they were being trafficked. I think that the policy objective here is very important, and I applaud you, Senator, and thank you and the First Lady for her steadfast work on this issue, and I'm very proud to be able to hear this bill today. So, of course, we do want to get into the language and make sure that we fully understand all of the important language that's in this bill. I'll call on Chairman Silcox for a question.
Thank you, Mr. Chairman. And I just wanted to really echo your comments that I really think this is important because I know of many victims, particularly children, who have been asked to commit crimes in the process of trafficking. So, I appreciate your efforts very much.
Any other questions for the sponsor? All right, so I asked Ms. Travis to join us just to give any comment if she'd like about our remaining two bills on the calendar. And so before you is Senate Bill 435, the vacatur bill. Does Gactel have any input on that?
No, sir.
All
Thank
right.
you so much for asking.
Thank you. Thank you so much for being in here. And we also wanted to invite the prosecuting attorneys to be in, but they're not out in the hall. I know they had the agenda, so they're aware that the bill was on today. But any further comments or questions at this point? All right, very good. I'll accept a motion.
Move to pass.
There's a motion to pass from Vice Chairman Reeves and a second from Representative Momptan. All those in favor signify by saying aye.
Aye.
Any opposed? All right, it's on to rules, passed unanimously. Who is carrying this for you?
Bonnie Rich.
Very good. All right, thank you, Senator.
Thank you.
Would you send in Senator Walker, please? Thanks. That's right. Appreciate everyone's patience here. We have one more bill on, and we've got the room for a bit.
Yeah, that was good. That was pretty good. The grass? I mean, that's a good one.
There wasn't time for philosophy.
That was a good one. Right over
Yes, sir.
here.
Front and center.
Right in front.
Good morning, everybody.
Morning.
Thank you for having me this morning.
So you're welcome to take off your mask while you're presenting your bill.
Thank you.
And
I just stepped to the restroom.
We'll go ahead and call Senate Bill 446 at this time.
Thank you, Mr. Chairman. I'm working off of LC 392610S, and this is a simple bill. In this economic times we're in, everybody's trying to do more with less and be more efficient, certainly at the state level, but also at the local level. And this bill allows, what this bill does is allows some efficiency at your local court system. Current law requires cash bonds. This deals with cash bonds, not when a professional surety is involved, just cash bonds. Current law requires those bonds to be held for 7 years if they're unclaimed after the bond has been released. This bill would change that to 2 years. I had a constituent that's clerk of the state court in Houston County, Teresa Hathaway, brought this to my attention, and so I started looking into it. I checked with my county commissioners and my sheriff. They thought it was a good idea, so then I talked to the Georgia Clerks of the Court Association and worked with Mr. Mike Holloman on it, and I have talked to the Bail Bondsman Association. They don't have any issue with it. It's just, I think it makes sense. So these are bonds that are unclaimed after the judge has released the bond. And there's various reasons a judge the bond would be released: a deferred sentence, a pre-sentence investigation, a court-ordered pretrial intervention program, a court-ordered educational and rehabilitation program, a fine, a dead docket, a death of the principal, or the inability to find the defendant. Teresa Hathaway's example was sometimes they've even left the country. I mean, maybe they've been deported by ICE, or there's no way to. So there's various reasons it could be released.
All right, any questions from members of the committee? Seeing none, I know that the clerks of court reached out. Are they supportive of your bill, Senator?
Absolutely.
Yeah.
Yes, I got some suggested language from the clerk of the court in White County. I think her name is Miss, let's see if I have that, but Dina Adams, and I worked with Mike Holloman on this, who represents that association.
All right, very good. Any other questions? All right, at this time I'll entertain a motion. All right, motion to pass and a second. All those in favor signify by saying aye. Aye. Any opposed? All right, it's unanimous on to rules. Who's carrying your bill?
Representative Blackman.
Very good. Thank you so much.
Thank you.
All right.
Committee.
We are finished with the bills on our agenda, so we're adjourned. Thanks so much.